Good afternoon, and welcome to the investiture of Professor Bob Lawless as the Max L. Rowe Professor of Law. Investitures are a time-honored tradition, conferring upon their honorees the authority and prestige of high political, religious, and academic office. In the setting of a world-class research university, such as the University of Illinois, investiture in an endowed position acknowledges the recipient's exceptional scholarly achievement and leadership in his or her field. And as I will detail in a moment, Bob has reached this very top echelon in his work. Investitures are also celebrations, and we're delighted to be joined by Bob's family for this celebration today. And this is a group where the orange and blue runs very deep. His wife, Patty, is a 1987 graduate of the university. His son, Thomas, who can't join us today because he's in class, let that be a lesson to all of the students, is a junior in the College of Media. His daughter, Rebecca, has been admitted as an undergraduate. I understand that there may be another university in this mix, so we'll just hope for the best on this one. His other daughter, Rachel, is also here. She's not quite ready for college, so we're not going to put any pressure on her to come to the university where she needs to be. We also welcome Bob's sister, Suzanne, and her husband, Peter, also both graduates of the university, and their children, Kelly and Carrie. Please join me in welcoming them today. In addition to celebrating the exceptional careers of our recipients, investitures provide an opportunity to honor donors whose vision and generosity make these events possible. The Max L. Rowe Professor of Law was established in 1982 by the late Max L. Rowe, a member of the College of Law's class of 1942. Mr. Rowe had a successful career in corporate law and was an avid supporter of the university and of the College of Law. The auditorium we are in today was named after him in 1994 in recognition of his generous contributions to the law building renovation project at that time. We are grateful to Max for his generosity and his vision. We also are delighted to be joined today by a distinguished campus leader, Dr. Abbas Benmamoun. Dr. Benmamoun is the Vice Provost for Faculty Affairs and Academic Policies and the Romano Professorial Scholar in the Department of Linguistics. An expert on comparative syntax and morphology of natural language and on heritage languages, he previously served on the faculty of the University of Wisconsin at Madison and the School of Oriental and African Studies at the University of London. As Vice Provost, he provides leadership in the areas of academic affairs and faculty affairs. Please join me in welcoming Dr. Benmamoun.
Thank you, Dean Colombo. On behalf of the Provost, the Chancellor, and the entire campus administration, it is my pleasure to join you all in offering my sincere congratulations to our distinguished colleague, Professor Bob Lawless, as the Max L. Rowe Professor of Law. We are celebrating and recognizing his significant accomplishments as a researcher, teacher, and engaged citizen of the university and the profession. And it is important to remember what a distinction it is to earn such an honor at a world-class university like ours. The investiture of a colleague with an endowed professorship is one of the most enjoyable events on our campus. It is also the most prestigious and most cherished academic honors of our university. And I think it is particularly worth noting that today's recipient of one of our highest honors is fully and truly a member of the Illinois family. He was born in this state and earned both his undergraduate and law degrees from the University of Illinois. Many years ago, this university offered Professor Lawless the opportunity to get a high-quality education, and he is returning the favor in full by offering us the fruits of his first class scholarship, and the gift of teaching and mentoring for the next generation of professionals and scholars. This is the kind of record that has earned him the Rowe Professorship we are investing today. And I am certain it is exactly the kind of impact Max R. Rowe expected when he established this award. Donors like Max Rowe have faith in the mission and capacity of our university. They believe that we can invest the resources that they trust us with to make the university a destination for top scholars and a venue for world-class research and teaching. If you look at the record of Professor Lawless, it is very clear that we are being true to the letter and spirit of the investment that alumni and friends make in this university. He truly embodies excellence in all facets of the university mission: research, teaching, and public engagement. So please join me in congratulating Professor Lawless and his family. We are all proud to count you as one of our own.
One of the gratifying parts of being a dean, actually, now that I think about it, maybe the only gratifying part of being a dean, is the ability to preside over events like this one, and it's particularly true for me today. I've worked with Bob for the last 10 years in a lot of different capacities, and over that time, I've developed a deep admiration for him as a scholar, as a teacher, as a colleague, as a mentor, and most importantly, as a friend. As Abbas noted, Bob is a native Illinoisan with 2 degrees from the University of Illinois. He earned an undergraduate degree with Bronze Tablet University honors in accountancy. He passed the CPA exam shortly after graduation, receiving the Elijah Watts Sells Award for top performance nationwide. He obtained his JD from the college in 1989, summa cum laude and Order of the Coif, serving as editor-in-chief of the University of Illinois Law Review. After law school, he clerked for the Honorable Harlington Wood, Jr. of the United States Court of Appeals for the Seventh Circuit. He then began his career practicing law in Washington, D.C., but soon came back to the college in 1992 as our very first faculty fellow. In fact, some of us will remember that we called our faculty fellow Lawless Visitors for many, many years. After his stint here as a faculty fellow, he joined the law faculty at the University of Missouri Columbia School of Law, where he later was named the Earl F. Nelson Professor of Law. From Missouri, Bob headed west to the University of Nevada at Las Vegas and was named the Gordon and Silver Limited Professor of Law there. He then returned to the college for what I hope is forever as a professor of law in 2006. At Illinois, Bob serves as the Associate Dean for Research and is the co-director of the Illinois Program on Law, Behavior, and Social Science. He has taught multiple courses, including our basic bankruptcy class, empirical methods in law, secured transactions, behavior and social science, and statutory interpretation of consumer law. His students praise him as approachable, pragmatic, helpful, and exceptional. All law classes should be like his, one student commented, while another opined that his ability to explain complex subjects is unparalleled. His only weakness, one student pointed out, is that he's a Cardinal fan. I, too, have had to overcome this as a long-suffering Cub fan, but it's okay. Bob's commitment to his scholarship and the academy matches his commitment to the college community and its students. Widely respected by academics, practitioners, and judges as one of the nation's top bankruptcy scholars, Bob has made foundational scholarly contributions in bankruptcy, consumer credit, and business law. His research is founded on empirical methodology, and a colleague claims that he is one of the small handful of empiricists in the bankruptcy field, while another asserts that the quality of his scholarship places him among the very top bankruptcy scholars nationally. One of his singular contributions to the field is his empirical study of racial biases in bankruptcy, which one colleague commented may be the most important paper on personal bankruptcy that I have ever read. Another colleague said that this study is generally regarded as the most important study in the bankruptcy field in recent years. A member of the American Law Institute, the National Bankruptcy Conference, and the American College of Bankruptcy, Bob is the new co-author for the 8th edition of Secured Credit, a leading textbook on secured transactions. He also joins Professors Jennifer Robinault and Tom Hewlin as the co-author of Empirical Methods in Law, the first book of its kind, a textbook on empirical methodologies as applied to the study of law. A strong believer in public engagement, Bob administers and contributes to the blog Credit Slips, a discussion on credit, finance, and bankruptcy. He also participates in the Consumer Bankruptcy Project, a long-term research project studying persons who file bankruptcy. He has testified before Congress, and his work has been featured in national media outlets like CNN, NPR, the New York Times, and the Wall Street Journal. A major figure in his field, heralded for path-breaking research, and a highly respected and beloved teacher, mentor, leader, and colleague. Bob, it is indeed a privilege for me today to recognize your many accomplishments and bestow on you this most deserving honor. At this time, would you please stand so I may present you with the medallion marking your investiture as the Max L. Rowe Professor of Law.
Thank you very much. So, yeah, thank you, John. As I just said to him, that was way over the top. Dr. Ben Mamoun, colleagues, friends, and family, I want to first extend very deep thanks for my family for being here. My daughters, Rebecca and Rachel, were a little chagrined to learn they did not have to miss school to be here today. I thought that was going to be a deal breaker, but here they are nonetheless. My son Thomas, as Dean Colombo mentioned, could not be here because he had a 4-hour class across campus. So we now know what is worse than a 4-hour long lab class. I especially appreciate that my sister, Susie Gill, and her husband, Pete, made the drive over from the Peoria area where we both grew up. My nieces, Kelly and Carrie, are here with them. Kelly, Carrie, as Dean Colombo alluded, we want you to become Illini someday as well. Your parents have thus asked me to read the following statement. What your uncle is about to say is not representative of what usually happens at this great university. Most everything else is more interesting. Of course, all my thanks today goes to my wife, Patty. We met 30 years ago here as undergraduates in that most romantic of all places, Wohlers Hall. This is actually true. It was then going by the even more romantic name of Commerce West. My calming and grounded approach to life has allowed Patty to flourish. My acceptance and tolerance of everyone, no matter their foibles, provides a constant example of how to lead a life well lived. Those who know Patty will be wondering if I have just lost my mind. For what I have said are her great qualities, not mine. Still, after even yet another dumb stunt like that, she's still going to be there for me. I don't know how I came to be so lucky to share my life with this wonderful woman. In August of 1986, I sat right about a little bit to, I guess, Eric Johnson's right for law school orientation. I thought I was going to be the only person in the room who was there that day, but now I see Judge Colin Bruce is here, who was also there that day for our law school orientation. So the lesson of the day for the students is that if you work really hard, after 29 years, you move about 20 feet. I really did. I sat right about where Eric's sitting. In law school orientation always involves a mock class, and we had been assigned Pearson versus Post. For those of you who do not know the case, it involves the weighty issue of whether a dead fox belonged to the hunter who was chasing it or the interloper who had shot it. Now, one question that should be occurring to you, for those of you who don't know the case, is, wait a minute, there were two parties willing to spend the time and money to litigate over who owned a dead fox. And, the answer is it was 1805. The litigants referred to themselves as Captain Post and Captain Pearson. Apparently, there was a lot of honor involved in who got that fox. The Mox class was being taught by John Cribbett, a former dean of the College of Law, former chancellor of the University of Illinois. And at this point, he had been teaching for 40 years and was a master of the law school classroom. So there I was, sitting in this auditorium with about 180 other brand new law students, every single one of us praying we would not be called on. Right? But about 10 minutes into the class, I heard Professor Cribbett say the two words I did not want to hear, Mr. Lawless. Right? Whatever answer I managed to stammer out was enough to prevent my immediate discharge from the College of Law. But later that evening at the reception for new students, I don't know, do we still do this? Yeah, right? We have the reception. Professor Cribbett walked up and asked me if I was Martin Lawless's son. Professor Cribbett perhaps had forgotten he had actually taken the time to meet with me as I was considering which school of law to attend. My father graduated from the College of Law in 1950 and had been in the very first law school class Professor Cribbett had ever taught. They had kept in touch over the years, and Professor Cribbett made clear that the reason that I was selected out for special treatment that day was that he had remembered my father. So thanks for that, Dad. Little did I know that my first teaching job would find me teaching a section of property opposite Professor Cribbett. It was an incredible experience to learn how to teach. I spent many hours in his office talking to him about the skill of teaching, and Professor Cribbett is the first person I need to thank today. The logic of cases like Pearson versus Post appealed to me greatly. Why, of course, right? It makes sense to allocate property rights in the fox only upon capture. Such a rule incentivizes people to develop their property into productive assets. Thus, we can apply similar reason to problems of oil and gas. They belong to whoever captures them, rather than under whosever land they might be. There appeared to be, as I was learning these cases, no mystery that could not be solved by the powers of the deductive logic of the law. And then in my first summer of law school, I fell in with a bunch of bankruptcy lawyers up in Peoria. Tom Perkins, who's now actually the bankruptcy judge up in Peoria, Lori Judd, and Tim Howard. They introduced me to bankruptcy, and the variety of issues that came up in that area of law made me think it was something that I might want to do. It was my great fortune to then to have bankruptcy classes with Charles Tabb, my then professor and now colleague and good friend. I was on the law review board, and one of the law review editors was some guy named Ralph Brubaker, right? Ralph also was interested in bankruptcy. Our work and conversations made me think that perhaps academia would be an interesting career. My students who wonder how I thought I would ever maybe make a good professor can blame Ralph for that, right? We both graduated and went our separate ways. We assumed we were finally rid of each other. Now we have offices 4 doors apart. Funny life. Charles picked up on my nascent interest and turned them into a passion for what has become my career. Charles, without your help and encouragement, I would not be standing here today. For that, I truly thank you. Charles offered the in-depth perspective on a topic that comes from studying with a leading scholar in the field. The only problem was that the more I learned about bankruptcy and the bankruptcy system, the less the deductive logic of the law seemed to explain it. And then one of the readings that Charles introduced me to was one of Elizabeth Warren's earliest scholarly works. In challenging some of the predominant theories of the time, Warren was unapologetically atheoretical. She offered, quote, a dirty, complex, elastic, interconnected view of bankruptcy, from which she could not articulate, quote, all of the factors relevant to a policy decision. She could not even claim she was dealing with an intellectual construct, she wrote. And she could not reason to meaningful conclusion by doing nothing more than thinking hard about logical consequences. Those words were contrary to most everything I had been taught about how law worked and what legal scholars were supposed to do. They have become my personal manifesto. About 6 years later, the person standing in the door of my office at the University of Missouri thus had an offer I couldn't refuse. It was August before my first year of teaching. I had just joined the faculty at the University of Missouri. I had not yet even set foot in a classroom. The person standing in my doorway introduced himself. He said his name was Steve Ferris. He explained that he was the new chair of the Department of Finance at the University of Missouri. He had some data on the cost of bankruptcy reorganization. Would I be interested in co-authoring? I took Steve's data home and a few days later told him I would like to join the research project. At the time, there was a raging debate about whether Chapter 11 was worth the cost. All of this debate was the sort of armchair theorizing that Warren had railed against. No one was really trying to figure out what were the actual costs and benefits of Chapter 11. And here was an established scholar offering to put data in my lap on at least half of that equation, the cost half. I spent 9 years at Missouri, with most of my scholarly time spent in collaboration with Steve. He taught me so much that the intellectual debt cannot be repaid. I often wonder what would have happened had I turned down Steve's offer to join him on that first paper. Thank goodness I did not. At the time, the data-driven social science approach to legal studies was not obviously a good career move. Indeed, when I went up for tenure, I had written a number of quantitatively based pieces. The law school powers that be had characterized them as that, quote, other stuff that I did. And indeed, they had to be arm-twisted into getting outside reviews for those articles so they would be considered as material in my tenure file. Things have changed, of course. In the late 1990s, I remember vividly a colleague's hallway conversation in which she said to me, the two of us are ELS scholars. And I said, what are you talking about? I befuddled, right? I asked what she could possibly be referring to and received what would now be the obvious explanation in the law school hallway. Well, of course, I'm talking about empirical legal studies. I've always marked that conversation as about the moment in time when the empirical legal studies field became self-aware. Westlaw provides some confirmatory evidence. Before the year 2000, the phrase empirical legal studies appears in the law reviews only 14 times. Since then, there have been 972 uses of the phrase. Another person I need to thank at this point is Bruce Markell. Now a professor at Florida State, he was at the time a professor at UNLV, and he was instrumental in recruiting me there and convincing me to come, and which in turn helped me to build a platform for my scholarship. Somewhere along the way of all of this, I had gotten a call from Elizabeth Warren inviting me to join the Consumer Bankruptcy Project, which has done some of the most important work on households and bankruptcy in the United States. Indeed, when I recently traveled to Europe, the CBP was held up as an example for European scholars to follow. I could not have been prouder to be associated with it. My work with the other incredible personnel from the CBP, Katie Porter, Deb Thorne, Melissa Jacoby, John Potto, Terry Sullivan, further developed my methodological skills. Even better, it has been made for some of the most amazing work that it will ever be my privilege to be associated with. The greatest joy from scholarship is the joy of finding things out. And because of the CBP, we know so much more about how the bankruptcy system affects everyday households. And every now and again, people even listen to the findings. While we are on the subject, I would be remiss not to acknowledge Senator Warren. I don't think I'll ever get used to calling her that. She has been a good friend and mentor, always generous with her time and support. I've learned so much from Elizabeth that, again, the intellectual debt can never be repaid. But as I was putting the talk together, there was one thing that I did want to mention, in particular, one lesson that I learned from her that I did want to share. In our work, one particular question she would always ask is, how do we know that? Woe unto you who presented at a seminar in front of her did not have an answer to that question. It is such a simple question, but it's a question we need to ask more often in legal scholarship. And it is a question that I always try to remind myself to ask. Now, for better or worse, the sum of these experiences have meant that I've come to be characterized as someone in the empirical legal studies movement. But as a beginning law professor, I would never have imagined that I would one day author a textbook called Empirical Methods in Law. In fact, I probably wouldn't even have imagined that I'd do that about 3 years before I wrote it. The blame for that belongs to Tom Ewing. who was chair of the appointments committee that recruited me here, and another person that deserves some of the blame is Jennifer Robinald. I forget which conference we were at, Jen, but I distinctly remember how you repeated to me, turned to me and said something I had said to you the year before when you were considering moving to Illinois, and you simply said, you have to do this. Tom's biggest pitch, though, was to come to Illinois, and so the three of us, Jen, Tom, and I, could co-teach a class on empirical methods. As we co-taught the class, it was apparent there were no good teaching materials, and Tom, again, pushed us to co-author a book, which we did. Tom told me he could not be here today, which is a good thing, because I've given him a steady and unrelenting stream of guff. See, John, I was going to say crap, but you said not to say crap. So, okay. Right. I've given him a steady and unrelenting stream of guff over the years, and I did not want Tom to hear me say anything good about him. Right? So this can be our little secret today. Right? In my favorite article of Tom's, he puts forth the example of a medical researcher or an economist from Moldova. Their important discoveries would be of interest to scholars around the world. Tom then contrasts these sorts of scholars to the situation of legal scholars who write only about phenomenon in their own country. Tom writes, easy for me to say, it is as if the Moldovan physician were to write only about prostate cancer diagnosis and treatment techniques within Moldova, or the Moldovan economist had a theory that applied only to decision makers in that republic. Tom dedicated his career trying to fix that problem in legal scholarship. I don't want him to know that his example was an inspiring challenge to me, so again, let's keep that between ourselves. My career had been previously focused on the same insular domestic approach he criticized, and it's been forever changed because of my work with him. Charlotte Koo, our Assistant Dean for International and Graduate Studies, also deserves my thanks for helping me see the importance of studying law across borders. There's been more than once wondering how I came to be waiting for my presentation to start in a classroom in Madrid or Rio de Janeiro or Zurich, or the most unlikely place of all, the chamber of the Supreme Court of Thailand. When I ask myself how I ended up there, those thoughts often come back to Tom and Charlotte, so thank you. Now, I've recited that personal history not to be self-indulgent. Okay, well, not only self-indulgent. We are facing a time of great change in our discipline and our profession. Our profession rightly demands more of our academic discipline. At the same time, our great research university expects us to excel at our scholarly mission. The people and experiences I've highlighted are the ones that have been the most influential to me, but as I think about why they have influenced me the most, it is because they are the ones that I hope have positioned me to serve both the university and the profession going forward. We need more scholarship that gets published in the best peer-reviewed journals and also has relevance to the problems facing lawyers, judges, legislators, regulators, policymakers, and the public. What stands in the middle of the demands of the profession and the demands of our university are socio-legal studies that often require methodologies developed in other disciplines. Such scholarship will be placed in the best peer-reviewed journals as the university expects and can also be of tremendous importance to people on the front lines of legal issues. One thing I like to say is that the law professor of the future is the person who will publish in the Journal of Law and Economics, the Journal of Legal History or Law and Society, or similar outlets, and who will also be in demand for a lunchtime continuing legal education seminar at a law firm. This is not a call for scholarship only for scholarship's sake. These approaches also strengthen our teaching mission. To do this sort of work well requires fine-grained institutional detail, fine-grained institutional knowledge of how the legal system works and how it interacts with society. This knowledge requires getting out of our offices, both physically and metaphorically. The knowledge that is acquired by such a scholar comes back into the classroom, allowing students to understand how the law works in action, not just in the books. These students will become more effective advocates and more in demand by legal service providers. Such a scholar's contacts with the profession also have the non-coincidental benefit of creating opportunities for our students. The scholar who has been in the field develops contacts she can deploy on behalf of her students. These are not just vague ramblings of a middle-aged academic. Strike that. These are not just vague ramblings of a middle-aged academic. Right? Many specific examples are already happening. Right? This is not a projection of what might happen in the future. This is happening now. And at the risk of omission of other good examples, let me just cite a few that have happened in these hallways. Our colleague Jennifer Robinold has done path-breaking experimental research on apologies in legal contexts that have advanced not only our understanding of how apologies affect legal outcome, but also the nature and psychology of apologies themselves. Needless to say, because this research helps inform lawyers how much will go into their pockets and their clients' pockets, it is of tremendous interest to these lawyers. It's my talk, so I'm going to mention my own work. Right? Lawyers groups from Washington, D.C. to Minneapolis to Kansas City to Oregon have invited me to come and discuss my own work on the implicit racial bias that seems to be at work in the bankruptcy system. In these talks, I stress the importance of listening to the client rather than imposing the lawyer's stereotypes of what the client wants. Our current visiting assistant professor, Stephen Rushin, has conducted innumerable interviews to understand what happens in Department of Justice actions when systemic police misconduct has occurred. I hear this issue's been in the news lately. This scholarship has been placed in great journals, and the world has also beaten a path to Stephen's door because he has knowledge the world wants. And I do mean the world, everything from HBO to Al Jazeera. Pamela Fohe now teaches, well, let's just say she teaches now at a different state university in between here and Ohio. I am still not over the fact, Pamela, that you're no longer down the hallway. While a visiting assistant professor on the faculty, Pamela compiled a database and did interviews to document what happens to churches that become bankrupt. Most people don't even realize that each year, and we wouldn't but for Pamela's work, that about 100 churches file bankruptcy each and every year. These bankruptcies can tear apart congregations and the communities they touch. Again, it is not surprising that national policymakers and national media now turn to Pamela as their go-to person on the topic. I picked Stephen and Pamela's scholarship as easy examples. When I go to academic conferences, I see similar scholarly voices from the newest scholars in the legal discipline. Coming up with these examples is easy in the sense that one can quickly find examples simply by thinking of new scholars. That thought turns me to a more parochial point. So far, I've made a plea that is generic to our discipline, but I also want to make a plea specific to this institution that has done so much for me. We have an opportunity to become one of the leading institutions that provides the socio-legal expertise to help solve society's most pressing problems, not just nationally, but around the world. This opportunity is also a threat. If we do not pick up that opportunity, we risk being left behind by institutions that do grab the Stephens and the Pamelas and the other new scholars of our discipline who will provide that expertise. Now, this sort of call I have made often gets perceived as some anti-intellectual resistance to deep theory, and I do not want to be misheard in this way. As a pragmatist, I have no foundational theory about what legal scholarship is. Indeed, one of my favorite sayings is that being a pragmatist means never having to say you have a theory. I only have the observation, as a pragmatist, that there is no shortage of production of deep theory about law, or perhaps more accurately, what just often claims to be deep theory about law. My call here is thus only for more of the sort of scholarship I described, not for it to displace everything else as the one, quote, true form of scholarship. In the end, I think that is what the profession wants, not an exclusion of one form of scholarship, but instead a more balanced approach from the law schools. In concluding, I want to come back to thank one person I've only briefly mentioned. Dad was a lawyer in Peoria, Illinois for 50 years. He was an Illini through and through. Indeed, when we had the offer to come back to Champaign, Patty will remember my dad looking at me, because don't cry, because you make me cry. We were weighing the pros and cons. We had very happy personal and professional lives in Las Vegas, and his response to me was simply, "Why in the hell wouldn't you take their offer?" And he was right, of course. In the end, it was one of the easiest decisions we've had to make, and I've been very happy we came back. But the reason I went to law school in the first place was that growing up around Dad's law practice, the idea of being a lawyer had sunk in very deeply. From this close-up perspective offered by my father, the practice of law was a real thing, involving people with real problems. One particular episode still stands out vividly. It involved an elderly client of my father's who called him immediately after her spouse had died. They'd been married many years, and he had passed away after a long illness. And I mean, she had just called. The body was still in the house. What should she do? Dad had been gone, took the phone call. He was gone for a while, but it made quite an impression on me that this old woman, having nowhere else to go, turned to her lawyer in what had to be one of the worst moments of her life. And in the end, as I was putting this talk together, it dawned on me that I especially need to thank is my father for this window into the law as a problem-solving profession. These early experiences now strongly influence my view of how legal scholarship needs to improve. Watching Dad in action taught me that law was not an abstraction of cold deductive logic. It was a real thing that affected real people. The people that administer and use the law need our help. So what I ask us to do as a discipline is to improve our body of scholarship to help lawyers solve problems with care, skill, and respect, whether they be problems facing multinational corporations represented by massive Wall Street law firms, or the problems of a newly widowed elderly lady represented by a modest lawyer in downstate Illinois. So thank you.
Congratulations, Bob, once again. Thank you for being Associate Dean for Research for Life. And as we adjourn, I invite all of you to join us in a reception for a reception in the Pier and Sarah Peterson Pavilion. And I think we can do one more round of applause for Bob.